Welcome back to It's Your Law. I'm George Curtis, and our mediator, Ron Lampe, is trying to settle this case and save the litigants some money. And we were up at the point where we separate into two different rooms. And so the defense has their room where they can privately discuss strategy and values and save a few bucks. So they get another case from XYZ Insurance Company. And the plaintiff and plaintiff's counsel are in still a different room where we're discussing the case and how we go about trying it and how a jury is going to react to this factor and that factor. And in the meantime, you're the shuttle diplomat going back and forth. Tell us how it works.
Right. Well, it varies from case to case, and you draw on your own experience. Let me just tell you about the one I most recently mediated. I first of all talked to the defendant because the plaintiff had made the last offer. I usually find out who made the last offer, counter offer, and then I go talk to the other side because we have kind of a rule, unwritten rule in the law that we don't ask people to bargain against themselves. So in this case, I went and talked to the defense, and I got a number, and I went back, and the lawyer started, it happened to be a female lawyer, she started putting her papers together, closing her briefcase, and getting up, and he said, "We're done, we're walking out." And I said, "Wait a minute." I said, "You've paid me to review your case, you've paid me to evaluate your case, I'm not going to let you go, figuratively speaking, until you've heard what I think." And they had given me the number as to what they thought the case, that is, the plaintiffs thought the case was. And I said, "I think if I were the plaintiff's lawyer and I got that kind of a verdict, I'd be doing somersaults in the air, because I think that's 1 out of 50 that you would ever get that kind of a number from a jury." And so then I go through the process of what a jury looks at and what the expectations are, et cetera, et cetera. And when I get all done, at least I keep them in the room. And then I go talk to the defendant, and long story short, after 4 hours we get the case settled. And that's a kind of case where as a mediator you feel really good, because you had the role that led to the settlement, whereas, and knowing as I do that if these parties had gone to trial, the only people that would have come out ahead would have been the insurance company lawyer who gets paid by the hour. The plaintiff's lawyer, unless it's a very large case, is not going to come out going through trial as opposed to mediation. And you and I have discussed that a little bit, but in fact, you might just tell people what you have to pay doctors and lawyers on a typical, say, a $30,000 whiplash case. What do you have in the way of expenses? You can tell them better than I can.
Well, actually, cases in that range and smaller, and that's the majority of the cases, we actually can't win at trial for our clients if we get anywhere near a reasonable offer, because typically we've got an emergency room doctor who charges the same as any other doctor to come and testify and doesn't want to do so. We've got the family practitioner that we have to produce because we have to prove the reasonableness, necessity of the treatment and that it was related to the accident. And then almost always they pass them on to a specialist, and these specialists usually charge more than $1,000 an hour to come and testify. Then you add in the factor that our clients are going to be out of work for a couple of days to be there, both spouses, and the attorney's fees go from 25% to a third. So at the mediation, while Mr. Lampe's in the other room, I have to say, all right, the offer on the table is $25,000, and I will admit I told you that a jury is going to come back with 30 or 35 grand. Let's figure it out. If we got 35 grand from a jury with those added expenses, you'd be about $1,000 ahead of taking the 25. Let's let Mr. Lampe see if he can jack them up $1,000, and you go home with more money than I can get you from a jury.
Right. And that also applies on the other side. I mean, the insurance company is paying a lawyer by the hour to go through preparation for trial, which is usually like 2 days for every day of trial. So they haven't incurred at the mediation stage, they haven't incurred a great deal of expense. So if they can settle at that point, they can pay a little bit more than they'd like. And as you say, the plaintiff can take a little less than they'd like. Both parties are ahead. And we all know from experience that in mediation, people usually don't come out feeling they've won the lottery, but they come out at least having the case resolved, number one, and number two, they're probably better off than if they'd gone through a trial.
And it gives them closure, and as you pointed out earlier, it gives them a chance to tell their story, which is what 9 out of 10 of them want. They want to be heard. And so that, thanks, Lampe, you've kind of ruined my trial practice. I used to get 25 jury cases a year. Now I'm lucky if I get 5. But what you're doing is a real service for the community and for the litigants, and I congratulate you.
Thank you, George.
And thank you, ladies and gentlemen. The Seventh Amendment guarantees litigants a jury trial if there's more than $20 in controversy. What it doesn't say is that jury trial is free. As a matter of fact, it's far from free. It's tremendously costly, especially in medical malpractice and products liability cases, where often hundreds of thousands of dollars are invested in investigation and expert witnesses. So sometimes you simply have to take a shortcut or forego entirely your right to justice. One of the major steps in the state of Wisconsin has been the development of ADR. People like Ron Lampe, who actually use their 35 years or more of litigation experience to help litigants tell their story, feel that someone has heard that story, and obtain some sense of justice within the reach of their pocketbooks. It's a great service. It's something that we should preserve, and we shouldn't be afraid to use. That's my opinion. I'm George Curtis.